Good morning, friends. My today's topic is rule of law. The doctrine of rule of law denotes that a state must be governed not by men but by law. The concept finds its origin in the work of Aristotle, where he remarks that in a state that functions on the principle of justice and equality, rule of law must be supreme, and the state as an institute must not be subject to the whims and fancies of its ruler. While the origin of rule of law date back to ancient Greece, the modern concept of rule of law, which is the bedrock for most democratic constitutions across the world, finds its root in the book The Law of the Constitution, authored by Professor A.V. Disse. Professor Disse, in his conception of the doctrine of rule of law, while echoing the thoughts of Aristotle, states that all individuals and entities must be subject to law and that no one, even the government or its official, are above the law. For such a functioning of the law, Disse points out that the law must be clear, unambiguous, and must apply to all equally. To further such a concept and bring clarity on the same, the professor Disse elucidated on three principles that characterize a smooth application of law. The first principle, which is the most relevant, is that the law is supreme and no entity can be above it. A reading of this principle would also mean that for the law to be supreme, it must be applicable to all. It cannot be arbitrary, and nor can it take away anything conferred by it in an arbitrary manner. So, in simple terms, for the law to be supreme, it must be clear, it must stay true to itself without falling prey to other powers inside or outside of it. This principle of rule of law in the context of our nation has found refuge within the basic structure of our constitution. In the case of Subcommittee on Judicial Accountability versus Union of India and others, while expounding the importance of the independence of the judiciary, a constitutional bench of this court held that the rule of law is part of the basic structure of the Constitution of India. The relevant observation made in this regard are as under. Before we discuss the merits of the arguments, it is necessary to take a conspectus of the constitutional provision concerning the judiciary and its independence. In interpreting the constitutional provision in this area, the court should adopt a construction which strengthens the foundation features and the basic structure of the Constitution. Rule of law is a basic feature of the Constitution which permeates the whole of the constitutional fabric and is an integral part of the constitutional structure. So it is from this principle of rule of law that the doctrine of legitimate expectation flow. So coming next to the second part of my presentation, that is doctrine of legitimate expectation. The doctrine of legitimate expectation is closely linked with and is essential for the functioning of the rule of law. This is because both the rule of law and legitimate expectation form the bedrock for fairness and predictability of the legal system. The doctrine of rule of law ensures that laws are applied equally and consistently, while the doctrine of legitimate expectation ensures that the public authorities act reasonably and consistently in their decision-making process. Together, these principles promote transparency and accountability in government action, and they help to maintain the trust of the people in the legal system. So now I am coming into details of the doctrine of legitimate expectation. The doctrine of legitimate expectation, in simple terms, is a legal principle that arises when a public authority makes a promise or acts in a manner that leads an individual or a group to expect a particular outcome. This doctrine, which flows from the doctrine of rule of law, is based on the idea of fairness and consistency in the decision making processes of the public authorities. When a legitimate expectation of a specific outcome is created by public authority, the said public authority is required to take into account such expectation created by it while making a decision that affects the interests of the individual or group concerned. If the public authority fails to do so, the individual or group has a right to challenge the decision and seek a remedy, such as an order to enforce the legitimate expectation. In Halsbury's Law of England, coming to fourth edition, volume 1, subclass 1151, the concept of legitimate expectation has been elucidated on and for the sake of convenience. The same is being extracted. What it says, legitimate expectations. A person may have a legitimate expectation of being treated in a certain way. What an administrative authority, even though he has no legal right in private law to receive such a treatment. The expectation may arise either from the representation or promise made by the authority, including an implied representation, or from consistent past practice. The existence of legitimate expectation may have a number of different consequences. It may give locus standi to seek leave to apply for judicial review. It may mean that the authority ought not to act so as to defeat the expectation without some overriding reason of public policy to justify its doing so. Or it may mean that if the authority proposes to defeat a person's legitimate expectation, it must afford him an opportunity to make representations on the matter. The court also distinguishes in licensing cases between original applications, applications to renew, and revocation. A party who has been granted a license may have a legitimate expectation that it will be renewed unless there is some good reason not to do so, and may therefore be entitled to greater procedural protection than a mere application for a grant. The courts of United Kingdom, while conceptualizing the doctrine of legitimate expectation, have adopted other key aspects of judicial review, such as paternity, unreasonableness in the case of R versus Inland Revenue Commissioner, ex parte MFK, Underwriting Agents Limited, and abuse of power in the case of R. Ban Bancourt versus Secretary of State for Foreign and Commonwealth Affairs to justify the existence and protection of legitimate expectations. The term legitimate expectation was first used in the case of Schmidt versus Secretary of State for Home Affairs by the UK Court. The doctrine, however, was not applied to the facts therein. Subsequently, in the case of O'Reilly versus McMahon, the doctrine of legitimate expectation was recognized as a ground for judicial review, allowing the individuals to challenge the legality of decision on the grounds that the decision maker had acted out with the power conferred upon it. Further, in the case of Council of Civil Service Union versus Minister for the Civil Services and R versus North and East Health Authority, the boundaries of doctrine were further elaborated upon. Notwithstanding efforts of the courts, some ambiguity as to when legis- legitimate expectations arise persisted, and in response, Lord Justice of Appeal John Lodge proposed the aspiration of good administration as a justification for the protection of legitimate expectation in the case of Nataraja versus Secretary of State for Home Departments. The doctrine of legitimate expectation was first introduced to Indian jurisprudence in the case of State of Kerala and others versus K.G. Magnan Pillai and others. In the aforesaid case, the government has issued a sanction in favor of the respondent therein to open a new school and to upgrade certain already existing schools. However, subsequent to the above mentioned sanction, a new direction was given by the government to keep the said sanction in abeyance. This court, while deciding the said issue, was of the opinion that the original sanction given by the government gave rise to legitimate expectation in the minds of the respondents. Yes. This legitimate expectation was, however, breached by the subsequent direction for events, and hence there was a violation of principles of natural justice. The relevant observation in this regard from the said judgment are as below. In other words, once the government approves an application for opening a new unaided school or a higher class in an existing unaided school and passes an order under Rule 2, subclass A, subclass 5, then the successful applicant acquires the right of legitimate expectation to have his application further considered under Rule 9 and Rule 11 for the issue of sanction order under Rule 11 for opening a new school or upgrading an existing school. It is no doubt true, as pointed out by the divisional bench, that by the mere grant of an approval under Rule 2A5, an application will not acquire a right to open a new school or to upgrade an existing school. But he certainly acquired the right and forcible in law to have his application taken to the next stage of consideration under Rule 11. The divisional bench was therefore right in taking the view that the general power of rescindment available to the state government under Section 20 of the Kerala General Clause Act has to be determined in the light of subject matter, context, and effect of the relevant provision of the statute. In Navjyoti Cooperative Group Housing Society and others versus Union of India and others, the original policy for allotment of land to housing society therein was based on the principle of seniority and seniority under the said policy was decided on the basis of date of registration. Subsequently, a change was made to the original policy wherein the criteria for deciding seniority was changed from the date of registration to the date of approval of the final list. The said deviation from the original policy was challenged on the touchstone of legitimate expectation by the petitioners therein. This court, while deciding on the said challenge, held that the original policy as well as the past practice of allotting land gave rise to legitimate expectation to the parties therein of a predictable pattern of allotment, and new change in policy broke such legitimate expectation. So this is all about the rule of law and legitimate expectation. Uh, Thank you for watching. See you again. God bless.